The Writ of Right. Prior to Henry II's reign, disputes concerning land were generally heard in the seigniorial courts of lords. Cases between the vassals of different lords might also be heard in the county courts. Although the king might hear cases or occasionally send a royal official to preside over a hearing, there was little centralised control over disputes. By the end of Henry II's reign, however, litigation concerning land, provided it was held freely, had fallen under the control of the king and his courts. The author of the legal treatise known as Glanvill explained that it was a custom of the realm that no one is bound to answer concerning any free tenement of his in the court of his lord, unless there was a writ from the Lord King or his Chief Justice. Litigation in a lord's court needed to be initiated through a writ de recto, or a writ of right. Such writs had become readily available, and they commanded the claimant's lord to hear, in his own court, a case concerning the right to the tenement. The case could, however, be transferred from the Lord's Court to the County Court through a procedure known as tolt, and from there to the King's Court through a writ of pone. A procedure was also introduced, probably at the Council of Windsor in 1179, whereby a tenant pleaded in an action of right could opt to have the case removed from the Lord's Court and brought directly before the King's Justices. A panel of 12 knights would be elected to form a grand assize, which would then answer the question of who, out of the claimant and the tenant, had the greater right to the tenement. The writ known as praecipe also allowed certain actions concerning right to be brought directly before the royal justices.